14th Amendment, Section 4. The validity of the public debt of the United States authorized by law, ... some language regarding the Civil War, not really relevant here, shall not be questioned. Okay? There are three questions just in what I read about definitional issues that might affect this discussion. First of all, the validity of the public debt. What is public debt? Does it mean issuance of, debt to pay for the Civil War, as the explicit language is there? Well, no, because it says including debts incurred for payment of pensions and bounties for suppressing insurrection and so forth. So that's just an example. So it's broader than just Civil War stuff. Okay. Well, is it just bonds and other type of debt security financial instruments that literally make us go into debt, or is it also various other kinds of obligations, like the promise to pay Social Security, the salaries of federal workers, the appropriated monies to spend on this, that, or the other federal program, which we haven't gone into debt for, but Congress has specified that we shall make these sorts of payments. There's scholars arguing on both sides of that question. Authorized by law, the validity of public debt authorized by law. What does that mean? Does that mean the debt ceiling itself Congress has to authorize? Or does it mean these spending bills, these appropriation bills? Shall not be questioned. Well, what does it mean to question the validity of debt? Some scholars argue that any action by government that heightens the chance of default is questioning the validity of the debt. So perhaps authorizing more spending.
So what is the debt ceiling? The federal government, like virtually all governments, is in the business of spending money. It pays the salaries of federal employees. It pays out benefits via entitlement programs such as Medicare and Social Security. It allocates money to agencies like the Department of Defense, the Environmental Protection Agency, the Department of Homeland Security, and so forth. And these expenses can add up. So in the 2013 fiscal year, the federal government spent approximately $3.5 trillion in connection with these and many other programs. Now, in general, you can think of federal spending as divided into two major categories: mandatory spending and discretionary spending. Mandatory spending occurs when the federal government pays out benefits or other payments pursuant to entitlement statutes, which remain in effect until repealed by Congress. Discretionary spending, by contrast, occurs in connections with appropriations bills, which tend to expire after a single fiscal year. The differences between these two types of spending are not especially important for our purposes. What matters most is that both mandatory spending and discretionary spending levels are ultimately established by Congress through the Article I lawmaking process. And they assume the form of statutory commands that the president is constitutionally obligated to carry out. Now, for a variety of reasons, the federal government often ends up raising less money than it spends within a given calendar year, thus resulting in a budget deficit. In 2013, for instance, the government raised only about $2.8 trillion in revenues while spending approximately $3.5 trillion, thus resulting in about a $700 billion deficit. So how did the federal government fill the $700 billion gap so as to make good on all of its spending obligations? It did so by borrowing money. Borrowing money is a time-honored American tradition. We borrowed money to finance the Revolutionary War, would later borrow money to help pay for the War of 1812, the Civil War, the construction of the Panama Canal, among other things. And remember that the Constitution itself quite explicitly gives Congress the authority to, quote, borrow money on the credit of the United States, end quote. So how did Congress carry out its money-borrowing powers during the early years of our constitutional republic? Well, up until the First World War, it generally did so on a bond-by-bond basis, enacting statutes that specifically authorized the Secretary of Treasury to borrow a specific amount of money for the purpose of paying for a specifically designated government project. But beginning in 1917, Congress took a different tack. It gave the Treasury Department a more generalized authority to borrow money on the credit of the United States, subject to a cap on the total amount of debt that the United States could incur. And thus emerged the federal debt ceiling, a law that sets a maximum on the total amount of outstanding debt that the Treasury Department is statutorily authorized to take on. The statute quite literally sets forth a dollar figure. It says, in effect, Treasury Department, you may borrow money, but only up to this limit. And if you want to borrow beyond that limit, you need to come back to us, the Congress, and ask for the additional authority to do so. So since 1917, Congress has periodically revisited the debt ceiling statute, most often amending the statute to increase the maximum amount of debt that the federal government is legally permitted to assume. Each year that the federal government runs a deficit, the amount of the national debt increases, and eventually the amount of that total national debt starts to run up against the statutory limit that Congress has set. When that occurs, the Treasury Department finds itself in a bind. It needs to issue more debt to cover the difference between its revenues and spending obligations, but it is legally prohibited from doing so by the debt ceiling statute. Thus, the Treasury Department must go to Congress and ask it to, quote, raise the debt ceiling, end quote. That is, increase the statutory maximum on the total amount of debt that we can take on. It's helpful to contemplate what exactly would happen if the Treasury Department suddenly found itself unable to borrow money to cover a budgetary shortfall. The short answer to this question is that no one really knows, but things would likely not be good. The most extreme and fearsome possibility is that the United States would end up defaulting on its debt. One of the various spending obligations of the federal government, after all, is the payment of interest and principal on existing IOUs. And if the debt ceiling were not raised, the government might potentially fail to meet some of these payment obligations, thus triggering the event of a default. Now, to be sure, this is not an inevitable short-term consequence of a failure to raise the debt ceiling. For a while, the Treasury Department might be able to avoid default by prioritizing payments to bondholders over various other government spending obligations. But eventually, the department might not even have enough cash on hand to cover even those payments, or it might just mess up, or whatever. And then that would be bad. Many economists shudder to even contemplate the consequences of a U.S. sovereign default. The general consensus is that it would spark a serious international financial crisis that would make the last decade's financial crisis look like child's play. So why would Congress ever hesitate before honoring a request to raise the debt ceiling? Well, one reason is that some members of Congress don't like the optics of the affair. Voting to raise the debt ceiling can look like voting in support of the national debt, which generally does not play well with the voters back home. More importantly, the very dire consequences that would follow from failing to raise the debt ceiling has led some members of Congress, most recently the House Republicans in 2011 and 2013, to see the statute as a massive bargaining chip, or some would say a massive bazooka aimed right at the president's head.
The debt ceiling is a bad idea as a matter of policy. We'd be better off to get rid of it. I don't think it's unconstitutional, as some professors have argued, but that doesn't mean that it is wise or desirable or at all helpful in trying to push us toward responsible budgeting. Like Warren Rudman, who I greatly admired, being a fiscal conservative is at the center of my political identity. But in my judgment, opposing increases in the debt ceiling is just about the worst way for fiscal conservatives to serve their cause. It distracts attention away from the real action in the budgeting process and decisions about taxation. And realistically, because nobody wants to have catastrophic default, Congress must succeed in the end and raise the debt ceiling. Its leverage is an illusion largely. So as a result, I call it, the debt ceiling is like a roach motel for fiscal conservatives. They can go in to make some fiery speeches, but they won't come out, at least until they have agreed to move on to other issues.
Whatever the president does in this scenario, short of acceding to congressional demands and signing the, repeal of Obamacare in exchange for heightening the raising the debt ceiling or what have you, is extra constitutional. And so there might be some validity or strong arguments for each aspect of the trilemma resolution, whether that be unilaterally blowing through the debt ceiling, whether it be unilaterally raising taxes, unilaterally cutting spending, each of which the president cannot do under our separation of powers scheme. As a matter of policy, as a matter of prudence, there might be arguments for each of them, but make no mistake that they are not constitutional.
So let us briefly examine some of the legal theories under which the president might simply decide to ignore the debt ceiling. Imagine in particular the following scenario. It's the year 2022. The debt ceiling is now at $20 trillion, and the outstanding debt obligations stand at roughly the same amount. Congress has refused to raise the debt ceiling, notwithstanding the president's entreaties to the contrary. And the Treasury Department does not have enough cash on hand to make all of the mini payments due next Monday. You're the legal advisor to the president, who comes to you with the question of whether she can instruct the Secretary of the Treasury to borrow in excess of the borrowing limit. What do you tell the president? Well, on initial inspection, you may be inclined to tell the president that such an instruction would be flagrantly unconstitutional. Here's why. Article 2, Section 3 of the U.S. Constitution provides that the president shall, quote, take care that the laws be faithfully executed, end quote. The debt ceiling is a law, the faithful execution of which requires federal debt to remain at or below $20 trillion. You might even point to Justice Robert Jackson's widely influential concurring opinion in Youngstown Sheet and Tube Company versus Sawyer, which notes that the president's constitutional powers are at their, quote, lowest ebb when they're exercised in direct contravention of statutory commands. And that might be especially so, you would continue, when it comes to borrowing, since the Constitution quite explicitly vests in Congress, and not the president, the authority to borrow money on the credit of the United States. Even assuming the existence of a trilemma, moreover, a critic might maintain that breaching the debt ceiling is not, in fact, the least bad of the three unconstitutional options. Perhaps, for instance, we could argue that Congress's refusal to raise the debt ceiling counts as the most recent expression of congressional intent, thus rendering a president's decision to ignore the debt ceiling most problematic from a separation of powers perspective. Or perhaps one could argue that the state of the law surrounding the president's so-called impoundment power, that is the power simply not to spend appropriated funds, is sufficiently uncertain as to render unilateral non-spending decisions by the president less constitutionally problematic than a unilateral breach of the debt ceiling.
This really is a constitutional crisis of sorts. The solution does not come from the four corners of the Constitution, and we can't sort of elegantly elide the dilemma, trilemma, whatever, away by saying what's less unconstitutional or what would create less damage in the policy world or something like that. What would be less likely to blow up the republic, say, because this Constitution's not a suicide pact. That doesn't constitutionalize whatever course of action you think must be taken.
So my first prescription is practice crisis avoidance as long as possible. And so that means the Treasury Department should be exercising all of its various extraordinary measures that allow it to legally delay the day of reckoning. So again, the president has a constitutional obligation to take care that the laws be faithfully executed, but here some law has to get broken. Lincoln's basic insight upon being inaugurated in 1861 and seeing the country in acute danger of dissolution was that his deepest constitutional obligation was to the survival of the Union. He sought to ensure that the damage done by the seceding states would not be a mortal blow to the constitutional order. So with that in mind, he took quite a number of steps that were constitutionally dubious on their face. I don't actually believe that he ever came out and said that he was violating the Constitution. But he certainly did some things that were hard to square with the Constitution, most notoriously suspending habeas corpus, such that he could arrest people he thought were working against the Union's interests. And he said to his critics of that action, who thought that he was violating the Constitution, "Are all the laws but one to go unexecuted, and the government itself to go to pieces, lest that one be violated?" So he's prioritizing the big picture of constitutional health over the particulars. Now, taken to its logical extreme, that principle could clearly be very dangerous. But taken responsibly, I think it can be very useful guidance for thinking about what to do in a debt ceiling crisis.